Assalamu alaikum, how are you all? So in today's discussion I will discuss about the vacuum point of the international law. Why international law is sagging the behind. International law is literally nothing on the concept of the international basement and the international philosophy. Bangladesh is strategically so high in interpreting the matter on the context of jurisprudence and the philosophy of the international law jurisprudence. But one of the greatest scholar, Sir Salmon said that international law is the vacuum point of the jurisprudence. But my question is that how is it possible? How a very big laws will become a vacuum point of the jurisprudence? Because in jurisprudence we can get some of the authentic principles, authentic identification, which is literally important and much more rational for the practice of the international practice or the international rational satisfactions. On hand, we are seeing that International Court of Justice or International Cricket Council has introduced lots of effective installment and effective activities in interpreting the ICC's activities and the ICC's dimension. For example, in the year 2023, ICC investigated the two matters. One is ICC directed warrant arrest with warrant against Vladimir Lenin Putin and Benjamin Netanyahu. But international authority, they have failed to do these activities. So on hand, I'm saying international law has effective issues. International law can penalize a person. International law can make any kind of interpretations over the legal issues and the legal matters. But in the pragmatic sense, in the pragmatic way, is it literally possible for the International Court of Justice and the International Cricket Council to reschedule the matter for the philosophical debate of interpreting the international law and the international dimension? So in that mechanism, we can mention the vacuum of the ICC's activities. So whenever the ICC came in the year 2002 with the hand of the Rome Statute, which has been developed in the year 1998. But 1998 to 2026, ICC could not establish a very good precedent in developing the international law, international community, international code of justice, even the international principles on the basis of the international circumstances. So this is on kind of big policy, this is on kind of big vacuum overlapping the issues of international law. So while I'm talking about the dilemma and limitations of the international law in the regular schedule, especially I have to mention that it is literally not possible for the Bangladeshi government or for the developing countries to establish, reschedule the matter of the international law overlapping the fundamental principle, fundamental jurisprudence or the fundamental rights also. For example, India is a big country. India has lots of political issues, social issues, or more than socio-political issues with Bangladesh. So is it possible for the Bangladeshi government to deal with these issues with Indian government with the hand of the ICC or with the hand of the International Court of Justice without any kind of justification, without any kind of dilemma? I have to mention that India has no strategy overlapping the issues of the Bangladeshi measurement. Even Bangladeshi government, they have also failed to reschedule the matter for the development of the Bangladeshi Code of Justice, Bangladeshi legal philosophy in the matter of the international law and the international mandate. So I'm not the interpreter, even I'm not the legal philosopher, but after observing the legal issues which has been directed by the ICC or the ICJ in the different types of time, I can say that International Court of Justice or the International Criminal Court, they can only work in the schedule of the developing country or the underdeveloping country, but they have no strategy, they have no plan for the development country, because the development country, they can try to get the philosophical strategy. They usually make the laws, they implement the laws. So what is the reason why they will under the supervision of their own made law? So this is the crystal and clear answer is that the Indian government actually they are the superpower. They have a strong connection with Russia, with the American people. So in that perspective, they are on kind of superpower in the Asian context and the Asian jurisprudence. So how is it possible to establish the ICC's concept, ICC's schedule, even the ICC's interpretation in the mechanism of Bangladesh? Either it is not possible for the Bangladeshi government to re-establish the matter again, or it is not possible for the Indian government to reschedule the matter, overlapping the justice or ensuring justice in the context of the Bangladeshi philosophy. So from my own experience, I can say that any country can go to the International Criminal Court or International Court of Justice, but there is a policy. The policy is principles of complementary. So for example, ICC has a very good affiliation to deal with this matter, but ICC will not be able to take the matter as a matter of justice whenever they have failed to re-establish the matter on the context, on the light of Article 17 of the Rome Statute. So I think that in that perspective, after observing the whole procedure, as far as it possible, we have to rechange, we have to reanalyze, even we have to reform the strategy of Article 17, Article 5, or more even Article 13 without any kind of justification measurement. So if it is possible in the future time or the future mandate, it is definitely possible. Otherwise, I have no strategy to change the judicial procedure or the non-judicial procedure of the International Court of Justice or the International Criminal Court. So without the development procedure, without the strong affiliation of the International Court of Justice issue, literally it is not possible for the Bangladeshi government to overlapping the issues, to reschedule the issues, to redistribute the issues for the ends of justice in the mechanism of Bangladesh. For example, Gambia filed a case against Myanmar in the International Criminal Court, and in that procedure, ICC directed a very good judgment regarding the matter of the Gambia and the Myanmar. Why it is possible? Because it is possible only for that region. Myanmar is not the sophisticated country. Myanmar is not the highly development country. Whenever the country is not highly development, highly sophisticated, or highly interpreted in the mechanism or in the power simulatory mechanism, it is not possible to establish the judgment, to establish the opinion of the judges over the burden of Bangladesh against Myanmar. So in that procedure, Myanmar is not very good enough. Myanmar's activities is bad, but they have failed to establish the principles of complementary in their own schedule. Even India has also failed to do so. So I'm humbly requesting all of the stakeholders to deal with this matter precautiously.